Good afternoon, Mr. Mthombeni.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm fine, thanks, Chief Justice.
Yes. I haven't seen you in a very long time.
Yes, Chief Justice, it's been a while.
Yes. Well, I told the commissioners that you and I served articles in the same law firm in the 80s.
That's correct.
At Channels Alberta, and I see you have included them there on page 4 of your paginated questionnaire. But since then, I think maybe I've bumped into you only once in probably 30 years, more or less, over 25 years.
Yes, Chief Justice, I think we bumped into each other twice. Once it was on a flight.
Yeah.
On the second incident, I think it was a labor law conference in Durban.
Oh, I think you probably have a better memory than me.
Yes.
No, thank you. Let me welcome you on behalf of all the commissioners to this interview. Thank you very much for availing yourself to be considered for appointment as a judge of the Labor Court. I will ask you some questions, and thereafter I will allow commissioners to also ask you questions. The questions we will ask you will be aimed at satisfying ourselves how you meet the selection criteria that this body has adopted for the selection of judges. In the course of questioning you, we may be robust, but nobody here has any intention of humiliating you or demeaning you in any way. You understand that?
I do, Chief Justice.
Yes. You hold a BProc degree, an LLB degree, and 2 LLMs and a postgraduate diploma in labor law. Is that correct?
That's correct, Chief Justice.
And you got your BProc degree from the University of Zululand. Is that right?
That's correct, Chief Justice.
And then your LLB at the University of Natal.
That's correct.
Is that right?
Yes, that's right.
I'm looking at what you have written here, but
it's correct,
I must confess your handwriting is not, it could be better. What I see, it looks like University of Natal. Is that correct? But you seem doubtful.
It's correct, Chief Justice. I think I'm in a wrong profession. I should have been a doctor. That's what they always say if a person has got a bad handwriting.
And then you got your LLM from the University of London.
That's correct, Chief Justice.
The first one, and the second LLM you got from Columbia University, is that right?
That's right, Chief Justice.
And the postgraduate diploma in labor law you got from what used to be called the Rand Afrikaans University. Is that right?
That's right, Chief Justice.
Yes. Did you get admitted as an attorney at some stage?
Yes, I got admitted in 1989.
1989. 1989.
Yes.
And did you practice for quite some time as an attorney?
Yes, I did practice. When I was a lecturer at the university,
Yeah.
I was practicing, we were allowed to practice. I was practicing on a part-time basis.
Yeah.
And when I left university, I joined the CCMA, and during that period...
Can I ask you to speak up so that everybody will hear your answers?
When I left the university, I joined the CCMA, and I was not allowed to practice.
Mm-hmm.
After my stint at the CCMA, I went into private practice until I joined the bar.
Mm-hmm. And how long were you at the CCMA?
I was at the CCMA for 2.5 years.
2.5 years.
Yes.
And were you full-time?
Yes, I was full-time.
What level of a commissioner were you?
Initially, I was appointed as a level 1 commissioner. Thereafter, I was appointed to KwaZulu-Natal as a senior convening commissioner.
Yes.
I was recalled to head office where I was appointed as the national senior commissioner.
Okay. Okay, but you say you were there only for 2 years.
Approximately 2.5, 3 years.
Oh, okay, okay. And did you do arbitrations as a CCMA commissioner?
Yes, I did, Chief Justice.
Yes. And your practice, all in all, how many years would you say you practiced full-time as an attorney?
Approximately, Chief Justice, excluding the years when I was at the CCMA, it would be about 17 or 18 years.
Yes.
Yeah.
And how diverse was your practice in terms of different branches of law?
It was diverse, but the bulk of my practice was on labor law. We had matrimonial matters, criminal law. Yes,
So you did labor law and criminal law?
yes, and the matrimonial matters.
Yeah.
Yes.
Okay. Were you practicing on your own?
I was the senior partner practicing with other attorneys and candidate attorneys.
Yeah. Okay. And how long did you teach at, you taught at Vista University, is that correct?
That's correct, Chief Justice.
How long did you teach there?
For 6 years.
6 years?
Yes.
What courses did you teach? Did you teach labor law?
I was teaching labor law and commercial law.
Yes. Okay. Now, apart from, or did you appear in the labor court, or do you appear even now in the labor court?
Yes, I appeared and I'm still appearing.
Sorry?
Justice. I'm still appearing, Chief
You are
Justice.
still appearing?
Yes.
How regularly do you appear in the labor court?
On average, I would say maybe once after 2 months.
Yeah.
Yes.
Do you conduct trials there and appear in motion court as well?
Yes, I conduct trials. I appear in motion courts for reviews. And I also appear for agent matters.
Yes. I see that at page 9, paginated 9 of the questionnaire, you were asked what proportion of your litigation work has been in the field of criminal law. That looks like 5%, is that correct?
That's correct, Chief Justice.
Administrative law, 15%.
That's correct.
Constitutional law, 0%.
Yes, that's correct.
Labor law, 80%.
That's correct.
And then it says other areas of civil law. Then you said commercial law.
That's correct.
But when you add 80 plus 15 and 5, don't you have 100% already? Can you see that?
It's 95. 95.
Is it 95?
Yes. 15 plus 80.
15 plus 5 is 20, isn't it?
Yes.
And then plus 80
It's 100%, that's correct.
is 100.
Yes.
So where do you get commercial law from?
In retrospect, I see that there's no room for commercial law.
Yes.
I accept that, Chief Justice.
Yes. Okay.
Perhaps if commercial law was also included there, I think I would have allocated a percentage to commercial law.
1% or 2%.
I would say 5%.
5%. Okay, all right. You have acted in the labor court, you said. Eh?
Yes, Chief Justice.
How long have you acted in the labor court?
Chief Justice, I cannot give you a figure, but I acted on a pro bono basis, I think 3 times, and it was 2 weeks each.
Please speak up so that we can hear.
Yes, I acted on a pro bono basis. I think it was for 2 weeks
Yeah.
on each occasion. Thereafter, I was invited to go and act. I acted for a month and a half.
Yeah.
Yes, it was not a full term.
Mm-hmm. Oh, when was that? Which year?
That was in 2016.
2016.
Yes.
Okay. So the one time you were acting pro bono, the other time it was not pro bono.
Yes.
Okay. How did you find it?
Chief Justice, I really enjoyed it.
Yes.
In particular, most of the judges I know, and there was a lot of collegiality.
Mm-hmm.
I was familiar with a lot of them.
Mm-hmm.
Besides that, throughout my legal career, I've been an adjudicator in arbitrations, disciplinary inquiries, and I really enjoyed being an adjudicator
Yes.
at the labor court.
Yes.
Yes.
Okay. What can you tell the commissioners about challenges that arise from the fact that the High Court and the Labor Court have concurrent jurisdiction in regard to certain matters?
Yes, Chief Justice. Initially, prior to the judgment of the Constitutional Court, I think that is Baloyi, this was the public protector. There was a lot of forum shopping, and as a result, there was uncertainty about which court actually has jurisdiction. But the Labor Relations Act grants exclusive jurisdiction to the labor court. However, that is not unlimited because in Baloyi, the Constitutional Court stated that in respect of rights that are entrenched in the Constitution, in respect of those disputes relating to those rights, the High Court and the Labor Court has got concurrent jurisdiction.
Yes, but I wanted you to tell me, maybe I should say, well, since you are saying after Baloyi there are no longer any problems, what were the problems that were there before Baloyi?
As I said earlier on, Chief Justice, it was forum shopping.
What types of cases were the subject of forum shopping? What types of cases were not the subject of forum shopping?
I'll just mention cases where the High Court did not have jurisdiction, like a purely employment matter. And then a party will approach the High Court. And the High Court may rule that, no, it hasn't got jurisdiction. This matter must be heard by the Labor Court. I'm thinking of such cases, Chief Justice, and vice versa.
Okay. What are the requirements for an interim interdict, temporary interdict?
Chief Justice, there must be a prima facie right. There must be a well-grounded apprehension of harm. There must be a balance of convenience. And finally, there should be no other satisfactory remedy.
Is that all?
Yes.
Okay. What are the requirements for a final interdict?
Chief Justice, there must be a clear right. There must be a reasonable apprehension of an injury. And finally, there should be no other satisfactory remedy.
If you get appointed to the labor court, you will deal, among others, with trials. Are you familiar with the requirements which must be met before you can draw an inference in a civil matter?
Yes, Chief Justice, in a civil matter, when as a trial of fact you are required to draw an inference, you've got to look at the totality of the evidence and look at the proven facts. Thereafter, you may find that there are a number of inferences. A duty of the trial of fact is to choose an inference that is most reasonable on the proven facts. That is contrary to Blom, where it must be the only inference, which is a standard in the criminal matters.
I will now give the Judge President of the Labour Court and Labour Appeal Court an opportunity to put questions to you.
Thank you, Chief Justice. Good evening, Mr. Mthombeni.
Good evening,
You
Judge
know,
President.
you last acted in 2016, I remember. But what happened to you after that? Where you haven't appeared very much, either in the Labour Court or Labour Appeal Court. Have you?
That's correct, Judge President. I have made myself available. The judges who are responsible for...
Please draw the mic closer to you so we can hear you.
I have made myself available, and the judges who are responsible for inviting acting judges are aware of that. However, when I was approached, I'll be having matters and I would not be available. And sometimes I'll be available, but at the last moment, I'll be advised that opportunities have been granted to practitioners who have not acted. And recently, the acting deputy judge president approached me for this term. And again, I wasn't available.
Yes. And that's why I'm asking, because since 2016, there have been at least 3 or 4 times that you've been contacted and
That's
asked
correct.
and approached to come and act, but you've never been available. But at the same time, we haven't seen you in court, so you must be busy with other practices.
Yes, like I said, I used to be quite very busy, but recently, like I said, on average, maybe once a month, yes, I've been busy with other matters, Judge President.
You do know that if you get appointed now, if you are recommended, that you will have to be to serve for at least 10 years, till the
Yes.
age of 75, you know that.
Yes, I'm aware, Judge President.
Okay. Tell me, have you been keeping in touch with the development of labor law? Because although you say 80%, my problem is that 80% might not be all court work. But if it's labor work, then you should be up to date with what's happening, because the labor world is so fluid, it's changing every day, every week. So have you been keeping abreast with developments?
Yes, that's correct, Judge President, I have been.
Thank you. Tell me, you know, until recently, derivative misconduct was a big issue. It's still a big issue. Or the Constitutional Court has said how to apply it and not readily to grant such misconduct, to agree to such misconduct. Do you know what is derivative misconduct and how it's applied, and what did the Constitutional Court say about that?
Yes, I do, Judge President. It's a concept that was developed by the courts when there were difficulties in identifying wrongdoers in group misconduct. Now, some people, part of the group, could have been in proximity of the wrongdoing. Not everybody may be responsible. Now, what happens is this: if there are some people, some workers, who were aware of the wrongdoing and they refuse to disclose to the employer, then they may be guilty, but they may not be guilty of the primary gross misconduct. They are guilty of a derivative misconduct, which is a breach of their duty, their fiduciary duty to the employer. Now, the Constitutional Court in Dunlop laid down the factors that should be taken into account. Sometimes since I've read the judgment, but all in all is that the people should have been present, and they would have refused to disclose the perpetrators, not because of their innocence, but because of their guilt. And the court also stated that not all the employees have a fiduciary duty to the employer. And those who do not have fiduciary duty to the employer may not be charged for derivative misconduct.
All right.
That's all I can report, Judge President.
That's fine, thank you. Thank you, I have no more questions.
Thank you, Minister. You are covered. Thank you. Commissioner Baloyi.
Good afternoon, Mr. Mthombeni.
Good afternoon, Commissioner.
Yes. Mr. Mthombeni, in your application, if at page 7 in that questionnaire, you were asked about whether any of your writings have been referred to in judgments, and you answer that you say have been cited with approval, and then your answer is insufficient time to do research to locate relevant decisions. Now, I don't understand this answer because you have a month from the date that the JSC advertises for positions, and you submit your application. I don't understand that answer, and I'm raising it with you because there's a particular theme that I think has emerged, and I will talk you through it. You may want to deal with this. How come you don't have time to research this? The question is asked, it's obviously important for the JSC to be aware of it.
Yes, Commissioner. I am not aware of decisions where my research work has been quoted.
You didn't say I'm not aware, you say I haven't had enough time. That's that part that I have a difficulty with.
Yes, Commissioner, if I had been aware I would have answered. But because of time constraint, I did not have some time to do research and find out in which decisions where my research has been referenced.
But you had a month to complete this application. What do you mean you didn't have time? It's that bothers me.
I understand that, Commissioner, but there were also other activities that I was involved in. I also focused, I focused my attention on the application. Yes, because it's very important to me. But there were some constraints, like I didn't have enough time to look at court decisions where my work was referenced.
Okay. In similar vein, a second issue arising from your application, at page 9, under question 6.3, you are asked which cases in which you have appeared would you regard as being the most significant and why? And you refer to the matter of Prasa versus NC Mulepo. And then you say the significance of it is that the court ordered the CEO and his attorney to pay costs, and then judgment cited with approval in subsequent cases. Now, I've looked at that judgment. The cost order, de bonis, is against the attorney, not the CEO. The CEO is not mentioned in that order. And that is the judgment of Moki, AJ. You refer to the, is this a mistake that you refer to the CEO?
Commissioner, I understand the question. However, there could be another judgment, because I recall that the CEO was ordered to do so. Instead, the CEO did not pay, Transnet paid, because this matter, I could have referred to, cited that, but there were also other cases I could have made a mistake by not citing the correct one. But both the CEO and the instructing attorney were ordered to pay costs. And it was also in the news. It was covered that the CEO was ordered to pay costs. Instead, Transnet paid. The CEO didn't pay.
Yes, you say Prasa versus Mulepo, so one works with what you have given us.
Yes.
And I'm saying to you that the Transnet versus Mulepo matter orders costs, you're correct, because the bonis were ordered against the attorney, but that's as far as it goes. But the other thing that concerns me here is it doesn't appear from this judgment that you were present in the matter. There's absolutely no reference to you here.
Commissioner, I appeared, and I heard the Commissioner referencing the Transnet matter. I did not appear in the Transnet matter. I only appeared in the Prasa matter. And it's correct that Acting Judge Moki was presiding.
So it is the correct matter, the Prasa matter with Moki?
Yes.
So I'm looking at the right judgment?
Yes.
Okay. And then lastly, I heard you agree with the JP that you last acted in 2016.
Yes.
Okay. And again, I mention this because I'm concerned that things that you have put don't seem to suggest that you've really looked at this seriously when you completed this application. I'm looking at your judgment in the matter of Janssen versus Legal Aid, and you've indicated there that that matter was heard in June 2017. Now, when you're completing this form, where you indicate you last acted in 2016, and when you appear and you're sitting there and you agree with the JP that you last acted in 2016, and yet there's a judgment here that you have referred to in your application. It's in fact heard, according to you, in June 2017. That sort of suggests to me that in applying yourself or in completing this application form, you didn't really give it proper attention. Is that not a fair statement?
No, Commissioner, I will disagree. I last acted in 2016, that's correct. However, if there's any reference to 2017, will the Commissioner refer me to that page?
It's your judgment. You have referred to the judgment.
Yes.
You recognize the judgment.
Yes, I do recognize
It's
the
Janssen versus Legal Aid South Africa. You recognize that?
I do.
Now, I've looked at the judgment. You didn't provide us with a copy of the judgment, and I've looked at the judgment, and I have it open here in front of me. And it says the matter was heard on 26 June 2017, and judgment delivered on 16 May 2018, in fact.
Commissioner, I did finish the JSC with a copy. And my answer when I said I last acted in 2016, I was appointed in 2016. The matter was part heard, and then you're correct that it was completed in 2017. That's what the judgment states. But my appointment to act was in September 2016, and the matter was part heard. I sat in that matter, I think, on 3 occasions, and it was finalized in 2017. That's why the judgment states 2017.
Okay, lastly, just to put it to rest, the very copy of the judgment that you've provided us with says the matter was heard on the 26th of June 2017 and judgment was delivered on 16 May 2018. That's a judgment that you've given us.
Yes, I think they're referring to the last day.
Okay. Thank you, CJ.
Well, I'm also seeing this, Mr. Mthombeni. That judgment, and I'm at paginated page 31, when it starts, it doesn't say that this was a trial. It says this is an application. So you were talking about apartheid. It says this is an application. It doesn't say a trial. And there is no indication, as far as I can see, that it had been heard on any other day other than the day that is reflected there, because the normal thing is that if a matter has been heard on a number of days, is that all those days would be reflected on the judgment to say these are the days on which it was heard, and then the date when judgment was given. Here there is only one day given, 26 June 2017, and delivered 16 May 2018. There is no indication anywhere that it was heard on more than one day. And as I say, unless I'm missing something, it doesn't look like it was a trial.
Chief Justice, it does look like it was a trial because the order that is given is an absolution.
Yeah, okay, so maybe it was
I think it's just wrong at the beginning when it says it's an application. It should have been a claim or a
referral.
referral under the Act.
Yeah, because when you say application, the normal understanding is that you are talking about an application on affidavit,
Yes, it's
isn't it?
Yes, page 49.
And some matters in the Labour Court are heard as motion matters, but they are trials. And I'm trying to see here whether there is any part that talks about any oral evidence.
Yes.
Yes.
It is there.
That's from page 33.
Oh, okay.
I mean, it still doesn't answer the question about when it was heard, but at least we know that it was a trial.
Yeah. Well, there are two issues that I wanted to raise about the same judgment. One is that it seems to, if it is true that it was heard on one day, which is 26 June 2017, and was handed down on 16 May, that means it took you about 11 months to hand it down. On the face of it, it doesn't seem to have been a complicated matter. Is that right? Or was it a complex matter?
Yes, Chief Justice, I was anticipating this question because
Yes.
I think one of the law bodies, I think the GCB, they've commented on it. Upfront, Chief Justice, I accept responsibility. I do not have any defense that I can use. All I can say is that this matter was challenging. It was, in my view, complex. And there were other factors which contributed to the delay. There was a record. This matter was heard in Cape Town, and I'm based in Johannesburg. There was a record. Whenever there's communication or submission of documents, they first submitted to the Labour Court in Johannesburg, and my clerk will inform me that the record has been delivered, and I'll make arrangements that either it's dropped off at my chambers or I collect it. And it took time for the record to come to Johannesburg.
Yes.
Yes. I'm not using that as an excuse.
Yeah.
Perhaps I could done things differently and pressed for the record to be submitted.
Okay.
And another factor is practice.
Yeah.
I'm not using that as an excuse. In retrospect, I would have done things differently. So
Yeah.
this also impacted on my practice. And that is one of the causes of the delay.
Yes.
So I'll say briefly, the communication between Cape Town and Johannesburg regarding the record and other documents
Yes.
was one of the delaying factors. And in my view, the matter was challenging and complex. And,
Okay.
and in addition, my practice also contributed to the delay. But
Okay.
as I said, that upfront, I accept
take responsibility.
Yes. In retrospect, I would have done things differently.
Yeah. Well, the last question arising for me here is, I see the order you made there, apart from dismissing the application for absolution, you declared the dismissal of the applicant to have been automatically unfair, and you declared that the respondent had unfairly discriminated against the applicant in terms of Section 6 of the EEA. Then you ordered the respondent to reinstate the applicant with full retrospective effect. Can you see that?
Yes, Chief Justice.
That would be an order that would mean that the employer mustn't just reinstate the employee or take him or her back. It would also be that from the date that the employee had been dismissed up to the date of reinstatement, the employer must give the employee full back pay and other benefits, isn't it?
That's correct.
But I then see that in number 5 of the order, you order the employer to pay the applicant compensation equivalent to 6 months' salary, calculated at the applicant's rate of remuneration on the date of dismissal. So the employee would get paid twice. Was it competent to make an order for compensation in circumstances where you have ordered a reinstatement with full back pay, or was it not competent?
Chief Justice, there were two claims. That the first one was the automatically unfair dismissal.
Yes.
And I make an order in respect of that claim. And then there was also the unfair discrimination in terms of the Employment Equity Act. And I ordered compensation in respect of the second claim.
Now, what was the basis of the unfair discrimination claim, was it not the same as the basis for the automatically unfair dismissal? I'm just asking. What was the basis? Was the basis not the same?
No, it was not the same according to the evidence and the pleadings.
Yes. So what was it in regard to the dismissal?
It was automatically unfair because the applicant was dismissed for his mental health, or to put it differently, for mental illness.
Oh, is that one of the grounds in terms of Section 1871 that renders a dismissal automatically unfair
Chief
in
Justice,
terms of the LRA?
Chief Justice,
I don't seem to have remembered it, but the law may have been amended, and I might not be aware.
no, that I must just be upfront that I haven't looked at this this judgment closely, quite closely recently. Like when you put this question to me, I was a bit reluctant to answer it correctly because I just needed to look at it closely and then answer appropriately.
Well, but of course you know that when you give us judgments that you say support your candidature, you are supposed to familiarize yourself, refresh your memory on them because you may be asked on them. You appreciate that?
I appreciate that, Chief Justice, could have been an oversight. I appreciate that.
Because when you leave the interview with questions that have not been answered, it can't be something that is positive in favor of your candidature if you are not able to answer certain questions because you didn't prepare on judgments that you gave us. You understand that?
Yes, I do, Chief Justice.
Yes. Okay.
Chief Justice, just want to follow up on this
Yes.
case.
Thank you.
Mr. Mthombeni, what I couldn't work out with this judgment of Janssen is the process that you followed, because it looks like in the same order, you dismissed an absolution and then granted relief, which is a very strange, it's a very strange order, you know, because, and there's no way in the judgment which shows the case actually being closed, the case of the defendant being closed. So I couldn't work out how you could dismiss absolution and then grant relief.
Commissioner Ngugaito,
Actually, that's important.
yeah, Commissioner Ngugaito, like there was a point in limine that was raised, and I had to make a ruling, and it was on onus. After the Labour Appeal Court dismissed or overruled me, then I realized, and there's also a mention that the question of onus was not properly addressed, and I admit that. So when I made a ruling on that point in limine, I said the employer has got onus. And then when the time for the employer to come and testify, the employer said they're applying for absolution. And then I did not grant absolution. Then
That's what I mean. I understand all of that. What I'm saying is that absolution is granted and then the case must be closed. And there's no way in the judgment where the case is closed. So that's what I couldn't work out. I've never seen a case where absolution is granted and then relief is entered against the defendant.
Just a moment, Commissioner. Like I said in my order on page 49, the application for absolution was dismissed. Yes,
Yes, but
Anyway,
what Commissioner Mthombeni is raising with you is when an application for absolution is made, when you dismiss it procedurally, what's the next thing that should happen?
Well, the matter is closed
By who?
because the absolution has been dismissed.
Yeah, who closes the matter?
Perhaps, Chief Justice, I'll ask Commissioner Mthombeni to put the question again to me because.
No, I think it's fine. I mean, we are spending a lot of valuable time on this, but anyway, thank you.
Okay.
I seem to be mixing a lot of things. Yeah.
Thank you very much. I don't know if I've asked the commissioners on the virtual platform. I think I did.
No question. Thank you very much, Secretary.
Thank you. We have come to the end of this interview, Mr. Mthombeni. Thank you very much for availing yourself. We appreciate it. You are now excused.
Thank you very much, Chief Justice. I would like to extend my thanks to the Judicial Services Commission for inviting me to this interview.
Thank you.